Johnson.
Yeah, please be seated. Good morning and welcome to the Arizona Court of Appeals for Division 1. I am Judge Jacobs. To my right, your left is Judge Perkins. To my left, your right is Chief Judge Goss. We are here for oral argument in two matters today, the first of which is Smith et al. Versus Dellaripa, Civil 23-0571. As you know, we record and live stream the proceedings, so if you wouldn't mind, please state your name and the name of your client when you begin, so that's there for the record and for people who are looking on from outside the courtroom. You also probably also know you have 20 minutes per side. You are not required to use your time, but you may. We do ask you to keep track of your own time. The clocks on the podium reflect your total remaining minutes, but if you say as appellant, I'd like to reserve 3 or 4 minutes, we'll try to honor whatever that is, but please mind your own time. Keep in mind also, please, that we have read the briefing, we have studied the record, and we discussed your case this morning in conference at 9 a.m. So, counsel for appellant, when you are ready, you may proceed.
Thank you, Your Honor, and I would like to reserve 5 minutes.
5. Great.
Yes,
thanks.
May it please the court. My name is Cobra Plucker. I'm one of the attorneys for the appellants, and with me at counsel's table is my colleague Chelsea Golinson. And I want to posit to you today that there are 2 truisms of human nature when it comes to the truth. The first is that most people try to hide the truth when they've done something wrong. And the second is that groups of people do a better job at finding the truth than a single individual. And those truisms are incorporated into our rules. It's why Rule 26 allows litigants broad discovery rights to seek out evidence and find those hidden truths. It's also why, under our system, juries, rather than single judges, make decisions about fact disputes to better find the truth. And unfortunately, in this case, the trial court disregarded these fundamental truisms, and he did that in 3 ways. First, in refusing to allow Dr. Smith access to his practice's office ally records, he violated Rule 26 and prevented Dr. Smith from obtaining records that were critical to this case, which he had an absolute right to obtain. Second, in granting summary judgment on the fraud issue, the court thwarted the ability of the jury to hear the facts that Dr. Smith had propounded. And finally, the court did the same thing in granting summary judgment on the unsound mind question, again, thwarting the ability of the jury to discover the truth. Now, I'd like to turn directly to the court's questions that they propounded last week in the order, and I'd like to take the last question first the court asked, which was, did the court err in finding the statute of limitations did not bar the fraud and unjust enrichment claims as a matter of law? And the answer to that is no. In this case, the court did the right thing. He recognized that there were disputes in the record about when accrual would occur, and he determined that the matter was best left for the jury. In fact, when you look at the record and what he was looking at, the trial court looked and saw that in late 2016, Dr. Smith noticed that his accounts receivable was increasing, and he was asking for office ally. And the response from Dr. Dellaripa was, well, don't worry about it. It's a computer error, and I'll look into it.
Counsel, to that point, we know we don't have a specified date, but we do know that your client started looking into this in late 2016. So isn't that an undisputed fact that your client himself identified that as a point in time at which he became aware of the problem and began to investigate it?
Well, Judge Perkins, for the purposes of the statute of limitations, as unjust enrichment applies, it's a 4-year statute of limitations. And so the trial court would have to determine with specificity that as a matter of law, the facts demonstrate that as of September 14th, 2016, accrual occurred. And there was no evidence in the record that would allow the court to make that conclusion. And so I think that the trial court absolutely made a clear and correct decision with respect to the unjust enrichment claim. And with respect to the fraud claim, which is what was left, the court was struggling indeed, and he was looking at 2016 and 2017. And what the court had determined was that the accrual date was when it clicked for Dr. Smith that Dr. Dellaripa was hiding something. And the court really struggled with when that moment occurred, as you can see from the record. But what the trial court did correctly here is what the Supreme Court told the trial court it should do in Walk v. Ring. In that case, the citation is 202 Arizona 310. In 2002, the trial court and the Court of Appeals were looking at a case and concluded that the statute of limitations accrued because they thought that the plaintiff didn't avail herself of a reasonable opportunity to discover a negligence that had occurred, despite the fact that she knew that she was injured, that there was probably something wrong. And what the Supreme Court said is it's up to the jury to determine the point when the plaintiff's knowledge, understanding, and acceptance in the aggregate provided sufficient facts to constitute a cause of action. And so the Supreme Court said it was error for the trial court and the Court of Appeals because while her failure to question the consulting doctors for information could be taken as a lack of diligence, or they weren't investigating something, it was really the sort of factual determination, a core factual determination that should be left for the jury. So in this case...
I'm going to move you along just because we have limited time. With regard to the tort claims and the 2-year statute of limitations, do you disagree that the undisputed facts establish a time frame in late 2017 but for the unsound mind tolling?
I do. For the purposes of appeal, we didn't brief that issue. We think discovery happened when my client obtained records from the insurance company that demonstrated that Dr. Dellaripa had changed the billing doctor on client RR from Dr. Smith to Dr. Dellaripa. We believe that's when accrual happened, but we also believe on the unsound mind questions, and I will get back to that if the court would like me to, but we believe that the unsound mind tolling allows those claims to continue.
With regard to the unsound mind claims and sort of the factual undergirding of those claims, I know you have a discovery dispute that's the subject of that motion to compel, and that goes to the records themselves. Is there any argument, have you raised any argument at some point that you lacked the ability to engage in proper discovery to support your unsound mind claims, or is that factual record properly set?
I think that factual record is properly set, Your Honor.
Okay.
I do. And going back to the questions that the court raised, I do want to move on to the next question, which was whether ARS 293410, enacted in 2018, applies to SWAG 1. I think the answer is yes, it does. And that's because 293410 and its corollaries 293110 say that the new LLC Act applies to all limited liability companies after September 1st, 2020. So the question is, did SWAG 1 exist on September 1st, 2020 in some form as an LLC? And the old statute tells us that it does. That's ARS 29784. And it says, on the filing of the articles of termination, the existence of the limited liability company ceases except for the purpose of suits, other proceedings, and appropriate actions. And so even though the articles of termination were filed, you still have this LLC that exists for this purpose, and I believe that that purpose includes these kinds of disputes amongst members, disputes about getting records. And so the prior statute allows us to obtain those records even though an article of termination had been filed.
Counsel, can you please address opposing counsel's argument that the Act doesn't apply to former members?
Well, Your Honor, I think that the new Act on its face applies to former members, and that's ARS 293410F. It says that that's subject to subsection L, a person dissociated as a member may have access to the records to which the person was entitled while a member.
Right.
So the new Act specifically allows former members to obtain that information.
Did you ever invoke the right under 3410L to seek attorney's fees for your frustrated attempts to obtain the records?
No, we did not.
Okay, and that's not in your brief in this court, right?
No, it's not.
Okay.
So I also think it's important to point out that the LLC Act isn't the only act that applies here, because as you'll recall, the LLC in this case was terminated as of November 6, 2016, and the practice became a partnership. The Office Ally program at issue was transferred to this partnership, and the statute is clear, there's been no change here, that Dr. Smith, as a former partner, was absolutely entitled to the records, and that's ARS 29-1033. And even if Dr. Smith didn't have a statutory right, we believe that he had a litigation right, because the diversion and deprioritization claims that he was making were absolutely right, were absolutely relevant, and the records would show those would help him on those theories.
Counsel, let me just clarify. So SWAG 1, up until essentially right about the time of Dr. Smith's departure, was an LLC. Would you say that Smith's and Dellaripa's records, although the trial court and even in the briefing we've been kind of referring to those as separate things, the whole problem here is that they are so highly integrated? Isn't the integrated bundle of records all one piece or one bucket that belongs to SWAG 1?
Well, it belongs to the practice, correct. And I think that brings me to your question with respect to 26B2B2 and whether that rule applies. Because I don't think Office Ally is really an opposing party's data source. I think it's the data source of the practice. And as you pointed out, Your Honor, it belongs to the practice. It's a practice program. According to Dr. Dellaripa, it's indivisible. And I think what that demonstrates is that it's both Dr. Smith's and Dr. Dellaripa's. Because if it's an opposing party's data source, why is it that Dr. Dellaripa has the ability to review and inspect Dr. Smith's data? Why is it that Dr. Dellaripa's wife and his new employees get to see Dr. Smith's records? And so what the trial court did was impermissibly favor one member over the other. Told Dr. Dellaripa, you get all the records, and Dr. Dellaripa, even though you're a member, you get none. And that's an abuse of discretion. I also want to point out that I believe on its face, 26B2B2 doesn't apply here. Because if you find that Dr. Smith has a right under the statute to obtain the records, the legislature has made it clear that they want to ensure that members and partners and former members and partners have access to the records related to their business endeavors. And so I don't think that the rule would trump the legislature's intent to make sure that access is provided.
Counsel, let's say that we agree with you on the motion to compel issue and we want to reverse that. Just hypothetically, that's the status of our analytical approach. Would the potential discovery that's subject to that go to just the unjust enrichment claim, or would it also go to your fraud claim?
It would go to the fraud claim. It would go to all the claims, Your Honor, because at the end of the day, what we believe is an Office Ally, billing records, records related to the collections rate of Dr. Dellaripa versus my client, is going to show fraud. It's going to potentially show misrepresentation. It's going to show conversion. We believe that there are going to be notes there that demonstrate those claims. And so, as we pointed out in our briefing, that's where this case got off track from the beginning. What the court should have done was to allow my client equal access to the Office Ally records in order to build all of his claims for fraud, misrepresentation, conversion, negligence, everything. And by preventing my client from doing that, it put my client in a position where he couldn't establish any of his claims. And that's demonstrated by the prejudice and the dismissal of the unjust enrichment claim, Your Honor. So I think ultimately, if you find that the court abused its discretion with respect to the Office Ally issue, that you should send all of the claims back to the trial court. And that includes the claims that were dismissed on summary judgment on the statute of limitations issue. And I do want to move there right now on the unsound mind question, because I do think that's critical for this court's determination of what to do with those claims that were dismissed on statute of limitations ground. So Dr. Smith presented several pieces of hard evidence for the jury to consider. And it doesn't matter if the trial court thinks it's good evidence. It doesn't matter if it agrees with the evidence. What Doe says is the only thing that matters is, have we alleged facts that are beyond the conclusory? And we have done that. Fact, Dr. Smith was diagnosed with an actual brain deficiency, progressive supranuclear palsy. That's not just depression or PTSD, where we don't know what the impact's going to be on someone's brain. In this case, we know that the disease damages brain cells. It affects body movement, it affects coordination, it affects thinking. It causes loss of interest in activities, causes impulsive behavior, causes trouble with reason and problem solving. It causes difficulty in decision making. So this particular diagnosis in itself is different from just PTSD or depression. Fact, as of February 2017, Dr. Smith couldn't work, not just as an anesthesiologist. He couldn't work at all. That's what Dr. Yasinski said in his notes. Fact, in March 2017, Dr. Smith was having difficulty with conversations. He was having difficulty staying organized. He was forgetting to pay bills. He was having difficulties remembering to take medication. He was overwhelmed by his daily tasks. This is a Dr. Wilson report. And if you look at it, Dr. Wilson says that these symptoms were manifesting themselves months before the March 16th visit. So as early as January 2017 is when a jury could start looking at these facts and concluding that Dr. Smith potentially had an unsound mind. Fact, the GAF score for Dr. Smith declined from 60 in May 2017, 40 in June 2017, 25 by January 2018. 40 indicates a major impairment in several areas. 25 indicates serious impairment in communication or judgment. It impacts his ability to function in almost all areas. By this time, he couldn't work, he couldn't sleep, he couldn't maintain attention. And what Doe says is that those kind of facts should go to the jury to demonstrate, for the jury to determine whether or not that indeed established unsound mind. And I would like to reserve the rest of my time. Thank you.
Good morning. My name is Joseph Brophy, and I represent the appellees James and Ginger Dellaripa et al. May it please the court. I would, like counsel did, like to start off with the fourth topic on the court's June 4th order. And the reason for that is that if this court were to decide that the Superior Court erred in not granting the initial motion for summary judgment on statute of limitations grounds, which applied to all of the claims, then it makes the rest of everything else that has been presented to the court essentially moot.
Quick clarification. Sure. Do I have it correct, though, that you actually did not argue this on appeal with regard to the fraud and the unjust enrichment claims?
That is correct.
Okay.
Yes. But it was the basis of the motion for summary judgment that all claims were barred by the statute of limitations. I also do believe that there's a dispute that wasn't really focused on in the briefing and was just mentioned by counsel up here as to whether or not unjust enrichment has a 3 or 4 year statute of limitations. I do believe there is authority for the proposition that it's a 3-year, and I do believe that's cited in our summary judgment motion at record 50. I think it's in a footnote.
But that's not in your appellate brief, apparently?
That's correct, yes.
Okay.
We do believe that the Superior Court erred in not granting that initial motion for summary judgment, and there are several reasons for that. First of all, every single allegation in the First Amended complaint took place in 2015 and 2016. And to state the obvious, if those allegations are good enough to state a claim upon which relief can be granted, and they all took place during those years, then that should be sufficient to start.
But that's not the standard. The standard is discovery, not the time that they occurred. Is that correct?
Yeah, you'd have to go through and read the actual allegations. And more to the point, I can direct you to Record 51, paragraphs 10 through 15. That's our statement of facts in the initial motion for summary judgment. And it is based entirely on Dr. Smith's testimony from his deposition, which means it's not contradicted. And he makes very clear at those points in the record that by the end of 2016, he knew what, you take it from the discovery rule case law, the who and the what as to what exactly he at least
I think that's probably a little bit of an overstatement of the deposition testimony, which I've read. He doesn't give any specific dates. He knows the who, but the whole point is that he didn't know the what in 2016.
By the end of 2016, he believed he was being stolen from. And when the underlying fact of every single claim that you're making is that you're being stolen from, that's about as good as you're going to get for accruing a statute for accrual for statute of limitations grounds. And I believe the person that he named was a non-party, Abby Loretto, but there's only a finite group of people, whether it's Abby or someone else, all the rest of them are basically the defendants, appellees in this case, that could be doing that. He was certainly on notice enough that he could have investigated had he chosen to do so.
So your theory is that he's on notice because he had a vague sense he was being stolen from by somebody other than your client? Do you have a case that says that's how you accrue a claim against someone like your client?
Well, I would refer the court to those paragraphs of the motion for summary judgment and to look at the testimony in there, because it's not just Abby Loretto. He's naming Dr. Dellaripa repeatedly in his deposition testimony. So
I thought your argument a second ago was that it was Abby and not Dr. Dellaripa.
well, again, you'd have to go and read the deposition testimony, but it's in there. Those are the two people that are named. The person that he believed was stealing was the administrator or accounting person.
That was my point.
Yeah.
So again, do you have a case about that? I understand where your statement of facts is. Do you have a case that says that, accrual against Dellaripa occurs based on suspicion of Abby?
Well, accrual against Swag One would, because Abby is an agent of Swag One, and so and Swag One is a defendant in this case. And that belief is essentially, it's not disputed anywhere in the record. Certainly, you're not going to look in the record and find anywhere where Dr. Smith says that he wasn't on notice or he didn't know. That testimony's not in there. There's no declaration submitted in response to our motion for summary judgment. And so by the end of 2016, Dr. Smith knew the what, and he believed that money was going missing, and he believed the who, that somebody at Swag One, Abby Loretto is who he named. If you look at the deposition testimony, he's not typically going to Abby Loretto, he's going to Dr. Dellaripa. And so there's only a finite group of people who could possibly be allegedly diverting these funds. This is not a toxic tort case, where the damage isn't going to appear until later. It's not a repressed memory case where, because of the trauma of the abuse, you don't know the identity of the tortfeasor or maybe don't even remember the abuse. Dr. Smith was aware, according to his own testimony, that he believed that he was being stolen from.
By all the parties in the caption? By all the parties in the caption?
Not by all the parties in the caption, no.
Okay. I'm really curious about something, because there's this discussion in the discovery about the legislature wants somebody to have this, and then there are discovery requests. In this case, counsel, did anybody have the early meeting required under Rule 26.1C1, disclosure of electronically stored information? When the existence of electronically stored information is disclosed or discovered, the parties must promptly confer and attempt to agree on matters relating to its disclosure or production. Did that happen in this case?
I don't know the answer to that, because I would not have been involved in the early meeting. I just don't know one way or the other.
But this office ally would be electronically stored information within the meaning of that rule, right?
Well, let me...
Kind of yes or no on that one, if you don't mind. Is that would be electronically stored information, right?
Yes, that's correct.
Okay,
Yeah.
so it would seem to fall within the scope of the prescription of the disclosure rules that people should meet about it. So doesn't it seem like that would be the best way to work this out, by having a discussion about undue burden early in the case like the disclosure rules suggest?
Well, you're not going to find this in the record, Judge, but since you're raising it, there were offers made to allow Dr. Smith and his attorneys to actually inspect Office Ally under the supervision of people from Dr. Dellaripa's office. And the primary point of that dispute, and I think what Judge Martin focused on during the oral argument on the motion to compel, was you're dealing with a very intrusive inspection here that necessarily gives Dr. Smith access to records that have absolutely no relevance whatsoever to this case.
So I think that's perhaps a bit of hyperbole, because the records, are integrated. Dr. Dellaripa has access to Dr. Smith's records, and Dr. Smith is looking to see if somewhere in those records we're seeing a transfer of clients from one to the other set, all of which are a single record data set under the ambit of the LLC. Isn't that correct?
I don't think so, and you packed a lot in there. The context here is important. Dr. Smith, in August of 2017, removed hard copies of all of his records from Swag One. You can find that at Record 51, Exhibit A, his deposition transcript, page 113 and 114. We know he had billing records because he testified to it, and he used those records to generate a very specific number of funds that were allegedly misappropriated, over $1 million. We also know it because he testified in September of 2017 that he was using.
Granted, he had the hard copies. We would like to talk more about the electronic records. I think that's the general direction we're going here.
Well, again, it's not that there were not records provided. The issue here, and this sort of gets us to the Rule 26 issue, is did he have a right to inspect the data sources of a company of which he has no affiliation whatsoever anymore? This sort of gets into also the LLC statute, where you do have under the current statute 3410 and under the old statute 607. Those are your records. And they do not apply to former members of an LLC.
What about 3410F? How does that work?
Well, that's a dissociated member. And if I can just use an example, under the old statute, ARS 297081 governs distributions to, and this is the term the legislature uses, former members. Under the new statute, ARS 293408A governs reimbursement to, and this is the term that the legislature uses, former members. Dr. Smith is not a dissociated member. He wasn't removed from the LLC. The LLC dissolved, and everybody went their separate ways. And by saying that.
But the records of Swag 1 still exist. They've just been imported into a new LLC.
Right.
Isn't this like a nice little sort of fiction that takes us outside the intent of the legislature in trying to give access of members of an LLC to their records?
The two examples that I just gave you from 29708 and 293408 stand for the proposition that if the legislature wants to grant rights to former members, it knows exactly how to do that. And it didn't do that in this case.
Counsel, I really don't understand how that answers my question. Are you saying that 3410F does not apply here because the updated statute doesn't apply, or are you saying he doesn't fall within 3410F, or are you saying both, please?
I'm saying he's not a dissociated member, so he doesn't fall within 3410F.
Okay.
He is a former member, and there is nothing in either the old or the new LLC statute that suggests that there's some obligation or right that exists in perpetuity for a former member after they leave. You're not going to find that in the operating agreement. You're not going to find it in the statute. And if the court were to have a ruling that said that former members have that right, it's going to have to reconcile why the legislature didn't say so, didn't use the term former member in 3410 or 607.
So what does the phrase dissociated as a member mean in F?
I believe that means the LLC continues to exist, but the member is removed. And that's what a dissociated member is. That just simply didn't happen here.
But if they had a right to discover the information under a process under Rule 26.1C through the disclosure process, it really doesn't matter if they have a statutory authorization, right?
I would actually, yes, I would agree with that.
So it has to be not available under the disclosure and discovery rule because it's the same standard under both, right?
Well, the difference is you run into that inspection, for our purposes here today, you run into whether it's an opposing party's data sources. And there is a rule that addresses, in this particular case, if the court were to decide it's an opposing party's data source, then the rule is very clear that there's only certain circumstances where the opposing party can get access to that.
But the process by which you're supposed to resolve differences about ESI begins in Rule 26.1C1, and it's not of record, and you aren't aware that it ever occurred.
No, I am not aware one way or the other. I just don't know. I do know, as I told you, and it's not in the record, that there were offers made to allow inspection, and those offers were declined. The insistence was that there needed to be unfettered access to this business, the records of this business, for which Dr. Smith was no longer associated.
And counsel, that's a good answer because it walks in the right direction. But the reason you're supposed to do that under Rule 26.1C1 to read further down in the paragraph is disputes must be presented under Rule 26D. And since it's not of record, obviously this dialogue never got far enough to be a 26D dispute about the Rule 26C1 process, correct?
There was a Rule 26D statement submitted that is in the record. That definitely happened.
Wait. A 26D statement that is about an initial discussion under 26.1C1? Because that was my question throughout, and it remains my question.
Correct.
Not something else, but that.
The 26D was about the motion to compel. It was not about the early meeting.
Okay.
Am I answering your question?
You are, because
Okay, all right.
that's how you might get back to in Rule 26B, the hard drive provision that you're trying to get back to as a defense, because it starts here in the disclosure process with this meeting confer that no one knows if it happened.
Right.
Yep.
Okay.
Okay.
Very quickly on the which LLC statute governs, I don't know that there is a substantive difference between the two. I will say, though, that the revised Limited Liability Company Act became effective from and after August 31st of 2019. The current Section 3 on applicability 3110, the appellants have taken the position that the new act applies to all LLCs regardless of timing. I would note that what that analysis skips over is that when the current LLC statute was passed, it was passed under Arizona Session Laws, Chapter 309, Section 10, in the year 2021. However, at the time that this lawsuit was filed, in September of 2020, the old version of the new statute, which was passed in 2018, became effective, I believe, in 2019, that was passed under 2018 Arizona Session Laws, Chapter 168, Section 6. And in Section 6 of those session laws, there is a savings clause that provides that the revised act, quote, does not affect an action commenced, proceeding, brought, or right accrued before September 1st of 2019. And so at the time that this lawsuit was filed, the legislation that had enacted the revised act had that savings clause in it that, and I don't think that there's any dispute here today, that the rights accrued, whenever they accrued, for Dr. Smith are all pre-September 1st, 2019 rights. And so I think because of that, it is 29607, the old statute, the old document production statute that would apply here, and that would remove, there's no disassociated member language in that statute.
Counsel, if I could, because
Yeah.
you haven't talked about it at all. The issue of his, of the accrual. What's missing in the evidence he presented of his condition of an unsound mind? Because there is evidence that you point to, but there seems to be evidence that they point to of an unsound mind, a medical diagnosis, other things. Why is the Superior Court right that there's no fact issue? What is missing in what they presented?
I'll tell you first and foremost what's missing, and that's testimony from Dr. Smith. The idea that he was of unsound mind comes solely from his counsel. It doesn't come from a healthcare provider. It doesn't come from an expert. It doesn't come from testimony from Dr. Smith. Never made that claim, ever. It's not in the complaint. You won't find it in the disclosure statement. This is, the way that it originally came out is lawsuit was filed, there was a motion to dismiss on statute of limitations grounds, which was denied by Judge Martin, and that's where your unsound mind argument came from. But to answer your question directly, the first thing, you're dealing with a bunch of medical records that they're citing to, but there's no claim that the definition of unsound mind was met, unable to pursue his understand his legal rights or pursue the legal action.
Is a doctor able to, the unsound mind isn't a medical condition. It's not something a doctor would diagnose. They diagnose other things. So why is that missing the problem here?
Well, it's not a medical condition, but it is something that could be supported by admissible evidence. It could be at least claimed by the party asserting it. I'm sure, as the court knows, the arguments of counsel are not evidence. And I would just, I guess I would ask rhetorically, what's the name of the healthcare provider that said he was unable to either understand his legal rights or pursue those rights? All of the evidence is to the
isn't the point. I think you were about to say all of the evidence is to the contrary, but your colleague here just stood up and gave a list of evidence that supports at least arguably unsound mind. So setting aside the contention that his counsel is the only one that argued this, the court had in front of us evidence to weigh. Isn't that something that properly goes to a jury?
There were a lot of things that were set up here and that were attributed to presumably something in the record, and it's not there. There's no testimony. There was a lot of things said about, well, here's what the symptoms are of this particular condition. It's not in the record. As a matter of fact, if you look at Dr. Wilson specifically said he's able to carry on his activities of daily living in her report. There's just, the record is completely bereft of anything for a jury to consider. It's a bunch of medical records, but there's a very specific definition of unsound mind, and it is a very limited group of people. You know, the term that's been used in the past is insane or incompetent. I mean, these are people that are truly disturbed. They're not just in poor health. They're not just having cognitive issues. You're talking about people that cannot function on a day-to-day basis by themselves. There's not even a claim that was the case in this case. It's not even argued. And there's certainly, there's no fact witnesses that support it, there's no healthcare providers that support it, and there was no expert testimony supporting it. You know, what you have are a bunch of medical records that report some, you know, admittedly some substantial health problems, but I believe the term from the case law is not everybody that has health misfortunes is of unsound mind.
But then it says it's a jury to decide that.
Well, it depends. There's the Doe case. I would refer you to, it's out of the federal court, and it was written by Judge Snow, who sort of synthesizes those two cases. There's the Doe case, and then there's the Flores case. The Flores case is a summary judgment case, and I would submit that this case is on all fours with Flores, where you come in and you make a bunch of you can't just come in and make a bunch of conclusory statements just because you have a health condition like PTSD. The word that's used is hard facts. What are the things that could not be done on a day-to-day basis? What are the activities of daily living? Who testified to that?
Okay, you're at time, counsel.
Okay.
Yeah. Thank you very much for your argument, counsel.
Thank you, Your Honors. And what you just heard from opposing counsel is he wants you to weigh facts. That's what the jury is supposed to do.
Well, he wants you to have admissible facts. Maybe you could talk about why what you said before is admissible and where it's admissible, potentially admissible evidence under Rule 56.
Yeah, absolutely. And I don't think there was any question about whether any of the documentation that was included in our response to the summary judgment motion was admissible. All of that was admissible. And it wasn't just us coming up with the ideas. You've got Dr. Yasinski's records. You've got Dr. Wilson's records. You've got...
So do I understand you to be saying that the diagnosis you discussed earlier, the symptoms and implications of that diagnosis, the information you provided in your initial argument, all of that is contained in the records that were attached to your response to summary judgment?
And if you take a look at our opening brief, it synthesizes all of those facts and tells you where you can find them in the record. And it was provided to the trial court in the response to the summary judgment motion. What he's trying to tell you to do is take a look at Flores and Flores controls, and that's absolutely incorrect, as we pointed out in our brief. Doe controls. And Justice Feldman excoriated the Flores court for doing what opposing counsel wants you to do, which is to start weighing the facts. That's for the jury to do. And there are facts for the jury to do that, just as we provided in our brief. I also want to address some of these other issues with respect to the statute of limitations on unjust enrichment. Your Honor, frankly, I just don't think this is a question. It was not something that was argued below. They essentially conceded it in the motions that a 4-year statute of limitations applies. If you look at San Manuel Copper Corporation, that's 8 Arizona App 218, it was decided in 1968. They evaluated whether a 3 or 4-year statute of limitations applies. Same statutes that exist today, and they concluded that the 4-year statute of limitations applied and that they would have no difficulty finding that such a suit for unjust enrichment is controlled by the 4-year statute of limitations. We should maintain what this court has done for 50 years. And in any event, the 3-year statute of limitations references come from a 2011 court case that just frankly just did not weigh the issue in the way that San Manuel Copper did.
Counsel, could you speak to his argument that unjust enrichment is a stalking horse to get around claims for which you had a legal remedy? Could you please speak to that briefly?
Yeah, absolutely, Your Honor. And I think there's a difference between an established remedy and an alleged remedy. And I think that what's important is that in Arizona, we can allege alternative grounds for a resolution. Unjust enrichment can be alleged at the same time a tort is alleged. And that's because in order for the unjust enrichment claim to be barred, there's got to be a clear, and there has to be an adequate, and there has to be a very convincing fact that the I'm sorry, Your Honor, I just want to make sure I get the language right. It's clear, adequate, and complete. It's got to be a clear, adequate, and complete remedy. And there's never been anything in this case that demonstrates that the tort claims that were brought by Dr. Smith were clear, adequate remedies. The court never adjudicated that issue in this case. Kistner was a completely different situation. It was a situation where the trial court had already adjudicated that there was indeed a breach of fiduciary duty, and you couldn't end run around the dismissal of that breach of fiduciary duty on statute of limitations ground because the court had already concluded that that remedy existed. That's never happened here. In fact, throughout the entire lawsuit, they've said that we don't have cognizable remedies. So here's where I think you are, Your Honor. I think if the statute of limitations issue is clear with respect to unjust enrichment, it's 4 years. That's preserved. I think you have to reverse on that ground. The fraud claim, I believe, is also preserved because there's a jury question dispute as to when that accrued. And I believe that unsound mind requires the court to reverse on the statute of limitations decision that the trial court made. And ultimately, that means this entire case and all the claims should be kicked back to the trial court, and we should have the opportunity to see the records in office ally. Thank you.
Okay. Thank you, counsel. Thank you, all counsel, for your arguments. We will take this matter under advisement and issue our decision in due course. We're going to adjourn and take a brief recess before hearing our second matter. Thank you both very much.